constitutional attorney for about 20 years, and I am in opposition to this legislation, even though I generally do religious freedom cases. I have done cases for plaintiffs, for ministers, for pastors, for religious groups under the Religious Land Use and Institutionalized Persons Act, the Free Exercise Clause, RFRA. I've represented a Baptist minister in Warner Robins who sought to protest. I represented a Baptist church in East Point who sought to locate downtown. I am opposed to this legislation for two reasons, and primarily I want to focus on the second, given the questions that have been raised. First, I don't believe that this bill is necessary. I've looked at the 22 cases listed. I've analyzed each of them, the 22 cases that supposedly say that this legislation is necessary. All of those cases prevailed under other provisions, whether it's the freedom of speech provision, the federal RFRA, the Equal Access Act. All of those cases won, except one individual who sought to proselytize on a university campus, but didn't even seek the permit that was required from that university. So I don't believe that the legislation is necessary, but the second reason is that I have seen how states have interpreted the federal and state RFRA to create problems. And I want to point to 5 cases. I've got a dozen decisions here, but I'm going to point to 5, and I'll talk about them very quickly. One is a United States Supreme Court decision from 2005, Gonzalez, 126 Supreme Court, 1211. There, a religious group sought to be exempt from the Controlled Substances Act, the primary anti-drug act of the federal government. They sought to use ayahuasca, a hallucinogenic tea. And the Supreme Court said, yes, you can. You can use that hallucinogenic tea. Now that decision, because RFRA only applies to the federal government, does not apply here. Once this legislation passes, it applies here. Second case, Dallas. The case of Big Heart Ministries versus City of Dallas. A religious group sought an exemption to food safety criteria and location restrictions. Essentially, food safety criteria, they said, didn't apply to them. They used Texas's RFRA. They won, and the City of Dallas paid more than $1 million in attorney's fees. Anti-discrimination laws. The Second Circuit held in 2006 that the RFRA trumped the age discrimination law. Anti-discrimination laws may fall based on this legislation. Refusing to provide medical services to patients. The 11th Circuit thankfully held that RFRA did not allow that, but the case went all the way up to the 11th Circuit in 2012. I have a dozen cases here. I can give them all to you. But the fact remains that some of these cases win, some of them lose, but all have led to persons asserting a veto power to criminal laws, to health and safety laws, to anti-discrimination laws, to child welfare and child abuse laws. 3 miles away from here, in 2005, Pastor Arthur Allen in the House of Prayer Church claimed, and this is the ABC News national headline, police call it abuse, pastor calls it God's will. And he directed that 41 children be beaten by congregation members. Do we want to open the door to him asserting a religious right to do that? I believe not. Thank you.
Wait a minute, yes. The point, who's got, that's yours, Ms. Beskin? Please.
Thank you, Mr. Weber. Your first example of unintended consequences or likely results, you mentioned the case where, the Gonzalez case, where RFRA was used to justify the use of hallucinogenic tea.
That's correct.
But that's kind of how this whole thing started. I was in law school from 1986 to 1989, and at that point, Native Americans had the right to smoke peyote because they did have a sincerely held religious belief to engage in that practice. And then, I guess in 1990 or so, the Supreme Court